So just hit your got it. Well, good morning, everybody. Thank you for joining us. We're absolutely delighted to see such a great turnout, but I'm not surprised because advanced medical directives is certainly a topic that we all can benefit from the most recent up-to-date information that we can get. And I would just remind everybody that your microphones are to be muted throughout the session. If you have any questions while you think of them and you hear something that Richard is presenting, please put them in the chat box. We will have 2 question periods. One will be at approximately 10:35 after his first presentation. We'll have a brief health break after the question period. Richard will come back and do the second presentation on wills. And after that, we will have questions on that segment.
Living wills.
So keep your cameras closed as well because we're too many people and it can interfere with the transmission. So I really appreciate that. And of course, you have Katia from Seniors Action Quebec, who's the interim executive director. And she is the one that's going to be leading things with Whitney, who's the administrative support, who will be sharing Richard's screen. And so now it's my delight and my honor to introduce Richard Goldman, who is a lawyer and plain language specialist with Éducaloi. He provides support to the English-speaking community groups throughout Quebec, offering legal information to the public. They do not offer legal services, but they do provide information and they have a marvelous website. Richard has been a lawyer for over 30 years and he has a wealth of experience in the community sector. He was a staff lawyer with Project Genesis. So some of us who have been around for a number of years certainly know of Project Genesis, the tenants organization, and the community group that advocates for housing, welfare, and other social rights. He's also served as a coordinator on a committee for the aid to refugees. And in addition, working at Éducaloi, Rick also serves as the supervising lawyer at the Just Solutions Legal Clinic of the Montreal City Mission. Richard, thank you very much, and it's your show.
Thank you so much for that wonderful introduction. Always a pleasure to present to Seniors Action Quebec, being myself a young senior. So I guess we can go ahead with the share screen, Whitney, and then we'll start the presentation. Okay, so I guess we'll go to, just go into full screen. And well, there you go. There's our topic for today, advanced medical directives and living wills. And so we can go already to the first slide. So here we go. I'm going to just give a brief presentation of Éducaloi. And Ruth, thank you for the shout out to our website because that's our starting point. And so Éducaloi, first of all, as an organization, we're an independent, nonprofit and charitable organization. We're not part of the government, although we receive a variety of funding from the government, including...
Stay there. Stay there. Sit down.
Okay, someone's got to mute their...
Could we please close our microphones because we heard all of that?
Okay, so we're not part of the government, but we do receive a variety of governmental and non-governmental funding, including from the Secretariat of Relations for Quebecers of English Expression, which is making it possible to provide today's presentation. The mission of Éducaloi as an independent organization is to explain the law to the public in everyday language. So it's easy to understand. As you know, the law can be quite complicated. Now we do this in various ways. Legal information on our website, which is what you're looking at here. So if you look at our website, you'll see there's various sections that you can click on. You see, first of all, the website, educaloi.qc.ca. Then there's different sections you can click on in the news, law by topic, that's on the left-hand side, web guides, publications, and about. So if you were to click on law by topic, that's where you would get to actually articles on the things that we're going to be talking about today, particularly advanced medical directives. So if there are further questions about it and you want more detail, you'll be able to find them on our website. We also offer print documents, which you can order free of charge through our website, or quite a few can be downloaded and printed up. We do workshops in the community, like the one we're doing right now. We create tools for teachers. A big part of Éducaloi is education. So actually in-class education, mainly high schools, some adult ed as well, presenting workshops specifically geared towards students in high school and young adults. And we have a variety of videos also available on our website. I see somebody's asking, how do I see your website? It's educaloi.qc.ca, or if you just Google Éducaloi, just put that in Google, you'll go right to our website. Okay, so we're based in Montreal. We're all in remote work right now, like pretty much everyone else who can be in Quebec. We're located in downtown Montreal, but we serve the entire province. We're a team of about 30 people, which includes lawyers, experts in communication, multimedia, and so on. Now, we, just in terms of what we do in workshops, we can't give people specific advice with like personal legal problems. Especially with a large crowd of, we have 80 participants or so, we can't get into detailed personal stories. And in any event, it's not something that Éducaloi offers in terms of legal advice on your personal situation. We're, as Ruth mentioned, we're here to provide legal information, and for actual legal advice, whether it be about a living will, advanced medical directives, pretty much any other legal topic that we would present on, you would have to consult your own notary or lawyer. On our website, we do have a section at the bottom of our homepage, Get More Help, where you have a variety of legal clinics, free legal clinics, information clinics that you can go to, information about Quebec legal aid, and so on. Okay, so that's for the, I guess we can advance to the next slide. So now we're getting into the real heart of the presentation, now that I've explained to you a little bit about what Éducaloi does. So this is a timeline that many people go through. Not everybody goes through the second part. Starting off with sound mind, which means understanding what you're able to do, understanding what you can sign, able to make decisions about your medical care and your finances and so on. Then, sadly, many people go through a stage of incapacity, of course, not everybody. And finally, everybody, until technology advances much more than we can ever imagine, becomes deceased at some point. Now, different documents, which we offer information and presentations about, come into play at different times. When we're of sound mind, the relevant document, if we want someone to do things for us, is a power of attorney. We're not talking about that today. When a person is deceased, the only relevant document is the will. Any documents they may have done before no longer have effect. When a person's in a situation of incapacity, so that's the middle of the arrow here, then several documents come into to great relevance. Advanced medical directives, the main topic for today, and living wills, which we'll talk about also today. And we were also going to touch on protection mandates, which are very relevant to situations of incapacity. Okay, so let's advance to the next. Thank you very much. So this is an important legal principle. It's very important for what we're talking about today, but it's very important for anything else, whether you sell your house, sign a lease or anything, sign a contract of some kind. for services. For any legal document to be valid, you must be of sound mind when you sign, and you must understand the choices that you are making. So otherwise, the document is not valid. It could be contested in court as invalid and might be canceled by a court. Okay, so those are basic, very basic principles for any legal documents, including the ones that we're talking about today. So let's advance, please. So advanced medical directives, what are they? They're relatively new since December 2015. So in Quebec law, they're a relatively new development. They allow you to express your wishes for certain healthcare treatments in advance. You can state in advance whether you will accept them or refuse them should you become incapacitated. So again, if we remember the previous slide, that they only become relevant in situations of incapacity. If you remain capable, many people remain entirely lucid their whole life before they pass away. Advanced medical directives would never actually come into effect for you should you remain lucid your entire life. But should you become incapable, they would come into effect and could be quite important. One thing I'll just flag here, it's flagged in the slide because it's often asked. Sometimes people confuse this with medical aid in dying. It's a completely other topic. They can't be used to ask for medical assistance in dying. It's just two separate things, advanced medical directives and medical aid in dying. I guess let's advance. Okay, so advanced medical directives, once again, I'm repeating, but we can't emphasize it enough. They only take effect should you become incapable of providing consent, should you not be able to understand and make decisions. They're also limited to 3 situations of incapacity, which we're going to look at, and to 5 treatments. So if you're satisfied, these cover, as you will see shortly, pretty much all the situations or most of the situations one can think of in terms of state of mind and in terms of the medical treatments, which we're going to look at. But should you have other wishes, they would have to go in another document, such as a living will or a protection mandate. Okay, so let's move on. So somebody I know asked, what do you mean by sound mind? And Ruth mentioned we're going to have question periods, but this does give you some idea of what is involved by unable to consent to treatment. Means you don't understand the nature of the disease, the nature and purpose of the treatment, the risks and advantages of the treatment, and the consequences of not receiving treatment. So this is when you would be considered, for the purposes of advanced medical directives, to not be able to consent, and therefore the advanced medical directives that we're going to talk about would come into effect. Okay, so let's advance, please. So these are the 3 situations in which they would come into effect. So as you're going to see, this part maybe is a little complicated. We'll take the necessary time and we could take questions, but they would only come into effect if one of these 3 situations applies. And then, as we'll see shortly, only for 5 specific medical treatments, which we're going to look at. So what are these 3 situations in which they could apply? There's a serious medical condition and facing the end of life, in a coma or permanently unconscious with no chance to regain consciousness or intellectual abilities, or dementia that seriously affects intellectual abilities with no possibility of improvement. So one would have to be in one of these situations, and the medical staff would have to evaluate that the person cannot make a proper consent, and an informed consent, and by understanding all the dimensions of the medical situation and the consequences, and then the advanced medical directives would come into effect. And so it has to be one of these three situations. Now, let's advance. And so mentioned, there's only for 5 treatments, okay? Now, please don't ask me for medical details about these treatments. I have no medical background whatsoever, and I won't be able to tell you more than what's on this page. So cardiopulmonary resuscitation, help to breathe with a machine, kidney dialysis, forced or artificial feeding, forced or artificial hydration. So these are the things that you can say yes or no to. Yes, I would want them, even if I become incapable, or no, I don't want them if I become incapable. And I'm in one of the situations that we saw before, end of life, coma, and so on. So it is a little bit complicated in the sense that they only come into effect in the 3 situations that we talked about if you're unable to consent to treatment. And it's only for 5 specific treatments. So if you've got another treatment in mind that you want to give an advance directive about, it would not be through advanced medical directives. It would have to be through another document. Okay, so those are the basic dimensions of the, once again, the 3 situations, the 5 treatments. And now we will look at how to actually prepare them, the nuts and bolts of how to prepare them. So let's advance, please. Okay, so there's basically 2 ways. Free form from the RAMQ. The RAMQ is the Régie de l'Assurance Maladie du Québec, Quebec Medicare. And we're going to go step by step, like very detailed with screenshots of what's involved there. But anyway, just so we're flagging that there's 2 ways to get the form. One is to download it, and we're going to go through the screenshots for that. Or if you're not a person who's comfortable downloading things, you can call a 1-800 number. You can also go to a notary, and the notary is the legal professional in Quebec who makes a wide variety of legal documents, doesn't go to court, but makes a wide variety of legal documents. Pretty much everyone deals with one at different moments of their life in Quebec, to make a will, to buy or sell a property, and so on, and make a mortgage. So most of you are familiar. Now, the advantage of going to a legal professional like a notary is they prepare everything for you. The disadvantage is you have to pay. They're private legal professionals. Now, in some other contexts, which we're not really talking about today, for example, a will, not a living will, but a will, there's a very big advantage of going to a notary, because a will done by a notary, and I don't want to get too far off topic, but anyway, just to flag, there's a big advantage because a will done by a notary is an authentic document and doesn't have to go through the courts. But with advanced medical directives, there's no legal advantage. There may be a practical advantage because the notary does the work for you, but there's no legal advantage. They're just as valid whether the notary drew them up or whether you do it yourself through the different steps that we're going to see now in the slides that come. Okay, so free form from the RAMQ. As you can see, you go to the RAMQ's website, which is there, and you can also, if you just Google RAMQ, just like Googling Éducaloi, you'll get there. And this is the homepage. And so you click there, as you can see, where the red circle. I'm not sure if you can see my cursor, but anyway, no, you can't, right? I'm not sharing my screen. So the red circle, issue, yes, thank you. Issue my directives in case of incapacity. So you would click there. so we can go to the next slide, okay? And then you click on, as you can see, red circle, click on download the form online. Okay, so let's go to the next slide. All right, so now you'll be directed to the Click Secure login. Now, Click Secure is something the Quebec government uses in a variety of services. Many of you might be familiar with it for Revenue Quebec. If you want to go online and see your tax file with Revenue Quebec, see your old notices of assessment and so on, you would have had to create a Click Secure login. But if you are a new user, as it says on the right-hand side of the screen, you can create a Click Secure for this purpose, which you'll also be able to use. It's like your kind of username with the Quebec government, with a variety of Quebec government services. And somebody who is not, all that handy with technology myself, I can tell you, I have been able to do it. So I think the average person with a relatively, some relative ease, level of ease with technology, like even going on Zoom, should be able to do this. With that said, as mentioned before, if you're not at ease with it, then you do have a 1-800 number that you can contact to just do it over the phone. And this, by the way, so you don't have to scribble things down very quickly, this presentation is available. We have shared the slides with Senior Action Quebec. So I understand that you could get this presentation if there's something you missed, a website, the 1-800 number, you'll be able to get it through Senior Action Quebec. Okay, so let's advance. So assume that you have logged in. So once you've logged in with Click Secure, the RAMQ asks you to confirm your identity again by the information on your Medicare card. So that, you have to have your Medicare card handy, but nothing very complicated there. Your health insurance number, that's the number on your RAMQ card, and the expiry date, okay? So let's advance. Okay, so then it's the green download box. So you're now on the page that lets you download the form. So you click download my form and you save the PDF to your computer. Basically you download it, like probably most of you are familiar. You download a Word document, you download a PDF document. Fortunately, it's in a handy format, PDF, which computers usually have no problem handling. And you just download, you just save it. You could save it anywhere on your computer, in your desktop, or a folder you've created so that you can find it easily. Now, it's important that to note that this form is personalized for you and only you, because you've put in your personal information. So you're going to get a form with a barcode, and only you can use it, nobody else. So you can't put in your information and your Medicare card and so on for your spouse or your sister or your brother. They will have to go through the process themselves to get their personalized form, okay? And you're going to have to print it. We'll go through it. We're going to go through the form, but at the end, you're going to have to print out all the pages, from start to finish, including even the instruction sheets at the beginning. Okay, so after you've saved the PDF file, you click the logout button. So we can, yes, that's it. Thank you. Beneath where your name will appear. And so then you log out. Okay. So let's go to the next slide. Sorry, I'm not being so clear. And you'll see a page confirming that, actually, let's go back. I'm sorry, I may have skipped ahead. Yes, I'm sorry. After you click log out, you'll see this page confirming that you have logged out. And it's important to make sure you've logged out, especially if you're accessing this by any chance, it's not your computer, it's a friend's computer, a public computer, someplace like in a public library, if they're open in your area. Just want to make sure that you log out. Okay, so now let's go ahead. Sorry about the confusion before. So you're going to see this page with important definitions. And so this will answer some of your questions. Like, we won't go into it that much, but remember I said I can't shed much light on that, or any light on medical situations, but here there are some definitions: artificial feeding and hydration, CPR, cognitive function, dialysis, and so on. So there's some more information. I can't go beyond that. And the definitions that you see online here, well, that's what you see, and hopefully that answers your question. But if there's anything that's unclear in terms of medical terminology and what would be, what's involved in a treatment that you are deciding, should I accept, should I refuse? Well, you really should be discussing it with your doctor. At the end, we're going to look at the form. Sorry, no, we're not quite there yet. Just 1 second. You're going to have to print out the entire document. It's 6 pages long, including all the instructions, which you're going to send to the RAMQ. Now we're going to, okay, so please let's advance. So now we're going to actually look at the form. And so remember, there's 3 situations. So there's going to be 3 pages. 3 situations, and in each of these situations, you're going to have to put, for the 5 treatments, whether you would like it, if you're in that situation and can't consent to treatment, or whether you refuse it. Okay, so the first one is end of life. I'm suffering from a serious and incurable medical condition, and I'm an end of life patient. But also, you're unable to consent. For any of these, you have to be unable to consent, because a person could be in an incurable situation, but still completely lucid. So then the advanced medical directives wouldn't apply. So assuming you're in this serious and incurable medical condition and unable to provide your consent, so now you're saying in advance, I consent to CPR, or I don't want. I consent to ventilator-assisted breathing, or I don't want it. I consent to dialysis, or I don't want it. I consent to forced or artificial feeding, or I don't want it. I consent to forced or artificial hydration, or I don't want it. So this is situation 1. The other 2 that you're going to see, the other 2 situations are going to be identical in terms of the choices you have to make. So let's advance, please. Okay, so situation in which cognitive functions are severely and irreversibly compromised. I'm in a coma that's deemed irreversible. I'm in a permanent vegetative state. So that's situation 2, that you're in a coma or a permanent vegetative state. Then you're making the same choices. Should that happen to me one day, I want CPR, or I don't want it. I want ventilator-assisted breathing, or I don't want it. I want dialysis, or I don't want it. I want forced or artificial feeding, or I don't want it. I want forced or artificial hydration, or I don't want it. Okay, so you can see for each situation, you have to go through the list and make your choices. Now we're going to look at the 3rd situation. Thank you. I have severe dementia with no possibility of improvement. Example, advanced Alzheimer's type dementia or other type of dementia. So this is a 3rd situation, and then the same choices. If I should be in that situation, I consent to CPR, or I don't want CPR. I consent to ventilator-assisted breathing, and so on. So exactly the same choices as in the other 3 situations. Okay, so I think we can advance. So that's the form. I mean, those are the choices. That's the real heart of the form, so to speak, those choices that you have to make. Then there's the signature page. You must sign the form in the presence of 2 witnesses who must also sign the form. They must be adults. The signature confirms that you're able to consent, that is, you're not capacitated at the time you sign, because remember, for any document to be valid at the time you sign, you must understand it. You must you must be able to understand generally what you're doing and specifically the document that you're signing. Okay. And then once you and the two witnesses have signed the form, you mail all 6 pages to the RAMQ at an address that's provided on the form. Okay, so let's advance. Then you will receive you'll receive a kind of acknowledgement of receipt. So you mail in the form, and the RAMQ puts your advanced medical directives in a register. Now, this is what is very, very advantageous about advanced medical directives, and I think it was a very good development in the law that the Quebec government introduced in 2015, because first of all, it's free of charge, it's easy to use, and it's in a register that any doctor in Quebec can consult. And doctors are supposed to consult them when you're in one of the 3 medical situations. It's also, even though that's the case, that any doctor who should find a patient in this situation and there's an issue, do they need CPR, do they need a ventilator, and so on, the doctors have to consult the registry. So that's part of the law. But it's a good idea to tell your loved ones that you have done this, so they won't be surprised to learn about them later if they need to be used. And so they can also tell doctors, although doctors are supposed to consult us as part of their work, they can also flag it for doctors that, that you have done this. So a few weeks after you mail them into the RAMQ, you should receive a letter like this from the RAMQ, confirming that your advanced medical directives are in the register. Okay. Okay, so that's essentially the information that we want to cover. This was somebody that, like one of my colleagues who did this. This is her actual file, so this is why her name information is blanked out. But she mentioned that she got this quite quickly. She got this in several weeks after sending it in, which, you know, for anything related to healthcare in Quebec is a pretty rapid turnaround. So this, that concludes the presentation part of Advanced Medical Directives. So we'll turn it open to questions now. So please go ahead.
Hey, Rick. So we have a couple of questions. The first ones have to do with the people who can sign as witnesses, who can sign the forms. Can your children be witnesses?
As far as I know, yes, they just have to be adults. Unlike a will, an actual will, where no one who has an interest in this, like who might inherit, could sign. Mm-hmm. No one has that kind of interest, like financial interest in this. And so as far as I know, any adult could sign.
And what happens if the witnesses who have signed pass away before you?
That has no consequence because the witnesses are not, it doesn't have to go to court. This is one of the big advantages of advanced medical directives. Once they're in the register, all the formalities have been followed, it's filled out, it's signed, it's sent in, they're in the register. They don't have to go back to the witnesses and say, you know, was this person really of sound mind or whatever. So that is not relevant. You don't have to worry about that. You don't have to have somebody re-sign it or anything like that.
Okay. Another question was, should I also provide my GP and specialist doctors a copy of my ADM form?
AMD.
Sorry, AMD. I've had one coffee this morning.
It's not necessary in the sense that every doctor in Quebec, as part of their job, is supposed to consult this. Should they have a patient who's in one of the 3 situations, you know, and which is generating an incapacity, and there has to be a decision about one of the 5 treatments. So it's not actually necessary. Now, having said that, if you're visiting your doctor, if you're lucky enough to have a family doctor that you visit periodically, there's no harm in giving it to them. I'm not actually sure what they'll say. I guess they will say, sure, I'll put it in your file. Your family doctor wouldn't be the one who is really involved should you be in a situation of incapacity in a hospital and there has to be a decision about, say, CPR. So I can't see any downside to it, but it's not really a necessity.
Okay, one question just came in about children signing as witnesses again. Can children sign if they're the heirs to the estate?
Well, it's a totally separate thing. So although today is not about wills, just to flag that in a will, you shouldn't have an heir sign as a witness. I believe that it's legally invalid. But here it's just not an issue. So even if they're the heir to your estate, this is just a totally different thing. It's not affected by your will or who could sign your will.
Okay. Oh, and this one just came in, which is interesting. Do most provinces have AMDs or is it unique to Quebec?
Okay. One thing I should mention at the outset, Éducaloi really can only give information about law that applies in Quebec. Now, some laws apply across Canada, like criminal law. We have information about that because it applies across Canada. But healthcare is a provincial jurisdiction. So we're not able to say, you know, what happens in Ontario with advanced medical directives, what happens in BC. So I just can't answer that. I suspect they have something similar because it's good common sense to have something like this in place, but I just can't answer, I'm afraid.
Okay. And another question that came in just a little before was, wouldn't the Medical Act cover to proceed with treatment even if you don't have an advanced medical directive?
Okay, so if you don't have an advanced medical directive, there's a hierarchy of people. First of all, I say this with a disclaimer that I'm not a medical professional, but having given this similar workshops where fortunately actually medical professionals were involved. In one case, there was a registered nurse who gave it, who participated in the workshop. In another case, a doctor. I think I'm conveying what they would have said. In an emergency situation, first of all, in an emergency situation, my understanding is everything has to be done to stabilize the person. It won't be possible to, for example, see if the person didn't want CPR. It's too fast. They can't take a chance. They have to err on the side of saving the person's life. Now, let's put aside emergency situations, and go back to what AMD is more aimed at. A person is in a stable situation, but they're in one of those three situations, like in a coma, advanced Alzheimer, and so on. So one of those three situations and one of those 5 treatments, CPR, etc. If you don't have advanced medical directives, first of all, you might have one of the other documents that we're going to look at. But let's say you have nothing, then there's a hierarchy of people that they consult, which is normally the spouse and then the children. And then they'll look even to see if there's no spouse or children, if there is any close friend that, let's say came to the hospital because there's no spouse and children that they consult. And if there's nobody, then the medical professionals have to make a decision. That's my understanding of the hierarchy. If there's nothing in place at all, okay, so it's going to be the closest family members that will be consulted, starting with the spouse and then going to the children.
Okay.
So, but of course, the whole idea of these documents is to have your wishes known, so your spouse or child doesn't have to be put in the situation of, no, don't give them CPR, yes, give them CPR.
Okay. I'm not sure if you can answer this one, but I'll ask it just in case. Someone wrote, what happens if a Quebecer has a major medical event, as in, hold on, another question just came in, as in a heart arrest in another province? How does one let the doctor know about a Quebec AMD?
I don't think there's any mechanism for doctors outside of Quebec. So you're in a totally different situation when you're outside Quebec. Now, there's a variety of other things, assuming a person's able to consent. Hospitals often have forms on level of care if a person is admitted. and which is somewhat similar. See, the thing is that the AMD is supposed to replace in a very uniform way and a universally accessible to the whole healthcare system, the most typical situations. But once you're outside that, we fall back on what was done before. So a person being admitted to a hospital in a potentially, life-threatening situation, but who is still lucid, may be asked to sign a level of care form, which could be similar to that. Like if I become unconscious and there is no hope of me, actually gaining, going out of a vegetative state, I don't want CPR. So there's these different sort of do-it-yourself forms that hospitals have, which are sometimes actually called living wills. So we're going to come back to that with living will. And that's kind of the situation that a person who had AMD in Quebec would find themselves in if they're on a 2-week visit to, Florida or Toronto or whatever, and something should happen. And then most likely in any province, whether it be Florida, whether it be Ontario, they follow basically the same hierarchy. If nothing is in place, they consult the spouse, they consult the children, and so on. But to answer the question as well as I can, I don't think anybody outside of Quebec would have access to your Quebec AMD.
Okay, and I think this is going to be the last one, so we can take our little health break. Once you submit your AMD form, can you edit it? Can you add something or change something or delete something, or does it stay as is?
Well, there is a procedure, and to be honest, I'm not, I think the letter, if we go back to the letter, because the short answer, there is a procedure to revoke them and to make new ones. If we go back, I think it's 1 slide or 2 slides. I don't know if we're going to, okay. Okay, it's in French, but to revoke, that is to cancel these directives, you have to use another form, revocation of advanced medical directives, that you can get on the same website. And of course, it says in an emergency, if you are able, you just give, you give instructions. I mean, AMD only come into effect if you're not able. Okay, and actually just before that, vous pouvez toujours modifier vos directives. Okay. Okay, so actually, I'm not the biggest expert in this, so I'm learning as we go. So this letter itself states that there is a form to modify and there is a form to cancel. So although we're not looking at those forms, there is a form to modify and there is a form to cancel. And it also mentions, of course, if you can consult your notary if you want the notary to do the form or modify the forms.
Okay, and there was one final question that came in that I missed. Someone had mentioned that there could be a concern. Is there a concern if an AMD is submitted in English? Would it be accepted?
Oh, absolutely, yes. For these purposes, both languages are accepted and official. I see that Éducaloi itself, sorry, going back to the last question about changing or revoking, I see that Éducaloi itself has an article on this. So I'm going to put it in the chat. Okay, let's hope that the link works. Paste. Okay, so you can try that out during the break. And if that doesn't work, I'll find the right link. I'll try it out too. And if that doesn't work, I'll put the right link in the chat. So on the procedures for modifying or canceling your medical directives, we have a little article about that on our website.
Great.
Okay.
So I think we'll take our little health break now. So I think if everyone can come back in 10 minutes, so 10:59. Does that sound good? All righty. See everyone then.
See you in 10.
See you in 10.
Welcome back, everybody. I think you all agree that was most informative. I really enjoyed that session. Didn't enjoy the topic particularly, but it's something that we all need to have the information on. Richard, you did a marvelous job, so thank you. And without further ado, just a friendly reminder, have those microphones closed. And as many of you as possible, close your video. Because we are a high number, so it keeps the transmission functioning properly. And Richard, if you're, oh, there he is. We're going to turn it right over to you, and we're going to learn now about living wills and how to make one. So without further ado, and once again, put your questions in the chat box, and Katia will ask them of Rick at the end. Thanks.
Thank you. So let's go back to the, yes, thank you. So we'll just advance. Okay, so living will, what is it? It's similar to advanced medical directives in terms of expressing wishes in advance. It can be broader than advanced medical directives. So as we saw, advanced medical directives are only come into effect in one of three situations of incapacity that we looked at, and only for 5 specific treatments. If you're thinking of something that's not covered, that wouldn't be covered by those situations or by those treatments, then you would want to do another document because they don't fit into AMD. Living will is a possibility, and we're going to look also at another document, protection mandate, which is a possibility. Okay, so living will can be broader than advanced medical directives. Now, it's not widely used in Quebec. Okay, so it can be used. It has a legal value, but it's not widely used, and it's not referred to anywhere in the law. Unlike advanced medical directives or protection mandates or wills, it's something that is, I mentioned it when we're talking about advanced medical directives, it's a kind of do-it-yourself thing that different hospitals have come up with, or different people have come up with, as a way of putting down on paper what their wishes would be in advance in certain situations of incapacity and certain treatments. But it's not widely used in Quebec. Why isn't it widely used in Quebec? Probably because we now have this system of AMD, which covers the most common situations and the most, what I guess are the most common treatments. Again, I'm not a doctor, but I guess if the Quebec Medicare chose those 5, the Quebec government chose those 5, it's because they come up the most. And there is another document which is more recognized in the law called the protection mandate. So why would, it raises the question of why somebody would prefer a living will over the AMD or the protection mandate. It's not obvious to me. I think now with AMD, the living will and the different documents that hospitals have come up with have much less use than they did before 2015. So let's advance. Anyway, we're going to look at those 2 documents. How do you make it? It doesn't have to follow a specific format. It doesn't have to have 2 witnesses. It doesn't have to be before a notary. It's basically, like I said, there's no structure or official recognition in Quebec law. So you kind of do it how you please. And it is, however, a manner of expressing your wishes for the same types of situations that we saw with advanced medical directives. So you could do it by hand, you could type it up and sign it. And in principle, it's valid, just like AMD, if you don't have AMD, or just like a protection mandate, if you don't have a protection mandate. So like AMD, you can indicate what treatment or treatments you wish to refuse if you become unable to express your wishes. And again, some hospitals have their own forms which they may call living will, or they may call something else like a level of care. You know, the hospitals are, you know, pretty much on their own. You know how many hospitals we have. Aside from the documents that are specifically recognized in our law, like advanced medical directives and protection mandates, they can kind of go the do-it-yourself route and come up with different forms, some of which, once again, they may call living will, and others they may call something else. Okay, so let's advance. Now, living wills versus AMD, big disadvantage of living will. It's not registered with the RAMQ or anyone. No one may know it exists or how to find it should there be an emergency and you become unable to express your wishes. Whereas the AMD, as we saw, are registered with the RAMQ and are accessible to any doctor in Quebec. So very, very big disadvantage of the living will versus the AMD. Although we saw there is in certain situations, there may be an advantage. We saw on the previous slide because they can be broader than the AMD. So if you can imagine a situation and a treatment that you're concerned about, but is not covered by AMD, well, then living will, or the next document we're going to look at, could fill in the gap. Okay, so let's advance. So my summary, you know, sometimes they say the least you need to know in some of the you know, advice books. My personal summary, unless you are concerned about a specific situation or treatment that is not covered by advanced medical directives, it's hard to see any advantage of a living will. Okay, so let's advance. So questions about living wills before we move on to the last document we're going to look at, which is protection mandates.
Well, there was one question that appeared. Someone asked that if they have a mandate, do they need a living will plus an AMD?
Okay, so if we're talking, just to make sure we're all talking about the same things, because unfortunately the terminology can be confusing. What is legally a mandate, which is also known as a power of attorney, if we were to think back to the sad continuum at the beginning, that's a document that, so again, mandate or power of attorney, all right, we're talking about that. They're the same thing in Quebec. Those are documents which are only legally valid while a person is able to make decisions. So without getting into a whole other topic and a whole other presentation for another day, and there's plenty of information about powers of attorney on our website. Just to give some very typical examples for context, you go away to Florida for, well, you know, in other times when it was easier to travel for a few months a year, you want your adult child to do your banking for you. Maybe you're in a duplex, you have a tenant, collect the rent, do any repairs. You know exactly what's going on, but it's a lot easier for your adult child living in Montreal than for you being in Florida a few months to take care of this. You give them a mandate. You give also known as a power of attorney, okay? That is no longer valid should you not be able to understand what's going on, should you become incapacitated, okay? Now, the confusing thing here is that the last document that we're going to look at is called protection mandate. So it has mandate in the name, and that makes it confusing. But protection mandate is much more like AMD in that it only comes into effect should you become incapacitated, okay? So I'm going to try to answer the actual question now. If you have a mandate, all right, so let's go back to what, you know, at the risk of repetition, what the mandate is. You go to Florida, you have an adult child taking care of your banking, your affairs while you're away. That has no effect should you become incapacitated, you know, it has no effect in terms of medical options should you become incapacitated. It simply has zero effect. It's not the right type of document. So to answer the question as best I can, even if you happen to have a mandate to take care of your affairs, another situation is you're disabled for a period of time, you can't get out, you want somebody to do things for you, do your banking or whatever. That mandate, even if you have that, you would still need advanced medical directives or some other document to deal with the situations that we're talking about today. That is, you become incapacitated and you want your wishes known in advance. So your mandate in the correct sense of mandate or of power of attorney wouldn't have any effect in that situation. You would still need something else. You could choose AMD, you could choose living will, you could choose protection mandate, because your basic mandate, power of attorney, doesn't cover those situations. Now, in order to answer I'm not even sure if this is the question, but it's a relevant issue. Is there any point in having a protection mandate and AMD at the same time? We'll see that there could be reasons to have that once we look at the next section on protection mandate, so we compare AMD with protection mandate. So we'll get to that. If that was actually the participant's question, we'll get to that in the next section. Okay.
Yeah, I think we're good. I think we can move on, Rick.
Okay, so last part, protection mandate. So what is it? It's another option for expressing healthcare wishes in advance. It names someone to take care of you and your affairs should you become incapacitated. For example, health. This is where it overlaps somewhat with the advanced medical directive, but it's much broader. Advanced medical directives, we saw what they do. They are very useful. We saw what they're limited to, 3 situations and 5 types of healthcare options. A protection mandate names someone to represent you, to make decisions, which you can give them instructions, specific instructions in terms of what to do, in terms of options for healthcare, but also housing, food, finances. So it's a much, much broader thing than advanced medical directives, even though it could cover the same things that advanced medical directives cover. So in that sense, you could get by, if you put everything in your protection mandate, you could get by without advanced medical directives, but there's a big advantage to having both. So let's continue. Okay, so similarities between them, because there are some important similarities between protection mandates and advanced medical directives. Both can be used to express healthcare wishes in advance, and both only take effect if you become incapacitated. Sorry, I'm just going to have a little sip of water. So, but we can advance. Now, advantages of protection mandate. It's broader, as we said, at the risk of repetition, than the advanced medical directives. They can cover, protection mandate can cover non-medical matters such as living situation, food, and finances. Okay, let's continue. Now, disadvantage of protection mandate versus advanced medical directives. Protection mandates must be homologated in court to take effect, and that can take several months. Before going to court, it's not registered anywhere. So you have to give someone a copy and tell them where to find, or tell them where to find it, you know, in my bedside table or whatever. Whereas, as we saw, and at the risk of repetition, advanced medical directives are registered with the RAMQ and are immediately accessible with no other formalities. Nobody has to go to court. Nobody has to take any legal procedures. That's a very big advantage. So that's why there could be an advantage, even though you can put all these medical instructions in a protection mandate, there's a very big advantage to, in a sense, separating out the protection, the medical part from the protection mandate and putting it in advanced medical directives. For the very reason that's presented there, advanced medical directives are registered with the RAMQ and immediately accessible with no other formalities, whereas protection mandate has to go through the courts. Okay, let's continue. So my summary, again, the least you need to know, in my opinion, advanced medical directives are simplest if if you just want, I think I could have cut out a word there. If you just want to express medical wishes in advance, and you're satisfied, again, with the 3 situations and the 5 types of medical care. Protection mandate is necessary if you want to cover other things besides medical issues, or I guess we could have added this, or other medical treatments or situations, in which case you could use either a protection mandate or a living will. Of course, you can have both. You can have the protection mandate and the advanced medical directives. And in my opinion, it makes sense to deal with if you're satisfied with the situations and the treatments that are covered by AMD, deal with the medical issues there. And from the protection mandate, you name somebody to take care of your housing, your food, and your finances should you become incapacitated. So it makes sense, I think, for most people to have both. Okay, so how to do a protection mandate? There's 2 ways. A notary, so then it's a legal professional. They will do all the work for you, but you have to pay them. Or kind of similar in a way to AMD, government form with 2 witnesses. So let's continue. Notary, notarial document. You don't have to worry about how it's drafted. Notary takes care of everything for you. And the notary also, sort of like the AMD, it's recorded in a registry of mandates. In that situation, you just have to tell people, I made a mandate, a protection mandate with notary so-and-so, so they, should you become incapacitated, they'll be able to get it from the notary, or if the notary themselves is no longer practicing, you'll be able to get it through the Board of Notaries. So that's a good thing. It is registered somewhere. It's also, although these things are not very easy to challenge, because the notary, part of the notary's job is to check that the person understands, able to understand what's going on and able to understand what they're signing. If you're worried about someday somebody challenging it, well, the notary's document is the most official. Okay, so let's advance. Now, the other way is the government form, kind of similar to the AMD. You have the website of the Curateur Public du Québec. And so and a 1-800 number, but we're going to look at the next slide at the home page. So there we go. There's the home page in English. You click on preparing your protection mandate, and that you get something quite similar to what we looked at. We're not going to go into it for protection mandate because it's not the main topic today, but it's pretty similar in terms of ease in filling it out. It's longer because it's covering a lot more situations than medical, but it's similar in terms of the ease in filling it out, similar to AMD. Okay, so you would click on that, you would get the interactive form to fill out. Okay, and some tips: ask persons or people you name. Now here, unlike advanced medical directives, you're naming somebody to do a lot of things for you. You're not just giving information for a doctor to look at. It's extremely important information in the AMD, but you're not naming a new person to do things for you. The doctor has to, provide healthcare, and they use the AMD to be informed. But protection mandate, you're naming someone with a big responsibility. Make decisions about your housing, make decisions about your finances, and so on. So you should ask the person if they're willing to do that. You could, it's a very big responsibility. You could add controls to make sure that they're doing their job properly. There's somebody who would have control of your finances, make decisions about your housing situation. You could add in that they have to report or get the approval of others. So report periodically or get the approval for certain decisions. Tell people about it. So, unlike the advanced medical directives or a protection mandate that's done with a notary, it's not registered anywhere. Even though you're using a government form from the Curateur Public, if you don't go through a notary, it's not registered anywhere. So somebody has to know about it. Of course, the logical person is the person you've named. You've named an adult child. They should know about it, at least know where to find it, and if not, actually have a copy that you give them. And then review every few years. People's situation can change. Your adult child who lived out west may have moved back, whereas your adult child who was living in Montreal may have moved to Toronto. Your people's situation change. So review every few years. Do you have the appropriate person? Are they still willing to do it? And so on. Okay, so I guess we can advance. I think that completes the presentation on protection mandates. So if there's any questions at this point, and if you thought about something from much earlier in the presentation, no problem, because this is the last question and answer session. So if there's anything, please go ahead.
So there are a few questions, Rick. One, which is just going back to the living wills. Is it a good idea to make a living will and to give it to your doctor or your relatives?
Well, the thing is that the living will, again, unless you're thinking of some situation of incapacity that's not covered by those three situations, coma, Alzheimer, etc., and or a medical treatment that's not covered by the 5 medical treatments, CPR, ventilator, and so on, I just cannot see any advantage of it. But let's say you do see some situation or some treatment that you think is not covered and you'd like to have that written down. Even then, I guess you could give it to your doctor, but it's tricky because your family physician may be, completely removed from the situation in the hospital should that treatment, the decision about the treatment come into play. So I think if you do go the living will mandate, the living will, oh my God, the living will route, which is not a mandate. If you do go the living will route, probably the best thing is to give it to your loved ones and say, look, should something happen, please show this. These are my wishes. Please show this to the medical professional. I don't know. I think that would be the best thing.
Okay. And there's a question about the protection mandate. If it's prepared by a notary, does the protection mandate still need to be, I think this is how you pronounce it, homologated?
Yes.
in
yes.
court?
It still has to go through the court. So remember I said at the beginning, and again, we don't want to get off topic, but there's a huge advantage of when you make a will to go to a notary in Quebec. We're only talking about Quebec. There's a huge advantage to a will because it doesn't have to go through the courts. It can be used directly. You can take it to the bank and so on. That doesn't apply to the living will. It doesn't apply if the notary does a living will for you. It doesn't apply if the notary does advanced medical directives. So to answer the question, unfortunately, even if you went through the expense of having the notary do a living will or a protection mandate for you, the protection mandate still has to go through the courts.
Okay. There's a question here. Someone asked, can you give instructions for what you want to happen in an emergency situation by using something like a medical or bracelet versus an AMD or a protection mandate? Or is it the same thing?
Okay, I don't know really what you can say with a medical bracelet. I thought it was, and I'm going into complete medical illiteracy here. I thought it was just like, I'm allergic to such and such, or I'm such and such blood type. If I'm right about that, then it's just a whole other thing. In theory, okay, so let's
it's a whole other category.
Yeah, let's look back at AMD, and we said that it's immediately available to any doctor in Quebec. But my own, this is, if there's a doctor or a nurse here and they know the accurate information, I'm basing it on what I heard, giving this workshop with those professionals present in the past. There's just not time in an emergency situation. It's a life and death situation. You give CPR, you don't have a minute, you don't have 30 seconds to spare, you give CPR. That's my understanding. If this is like an emergency, not that somebody's been in the hospital for 2 weeks and has a heart attack, because then there's plenty of time to have consulted the AMD. So the question was, can you give instructions? I think the participant's question was, can you give instructions for emergency? I think legally it's theoretically possible. I just don't know, like, practically how it could be done by the nature of a medical emergency. So I think if you gave something to your loved ones that said, I'm not in hospital, I'm not incapacitated, but should I have a heart attack and be incapacitated, tell the give them, the emergency responders, this paper signed by me saying I don't want CPR. I think that would be legally binding, because it's like you're giving your instructions in advance as if you were able to give them in person now. I just don't know if, practically speaking, it could ever happen. So.
Okay. There's a question here, and I think this is what the person is asking. What happens if your witnesses who sign your AMDs live abroad or in another province? Does that change anything?
No, there's not really. Since the witnesses don't come into play sort of in a normal situation of using the AMD. I see actually that can AMD be challenged? For some reason, interestingly, the questions are popping up on my screen as opposed to in the chat, but Zoom has many wonders to it. And that ties in directly. AMDs, like any legal document, whether it's a will, whether there's a protection mandate, can be challenged in court on the basis that the person didn't understand, wasn't able to give consent, was not of sound mind, was not able to understand what was going on and understand what document they were signing. So any legal document can be challenged in that way. Once again, the practicality is not that obvious, because AMD, when will your family even know about it? I mean, you could, it's a good idea to tell them, but let's say you didn't want to tell them because you're afraid that they're going to challenge it. When will they know about it? It's pretty much just when you're in hospital and in this situation of, should they give CPR? Should they put you on a ventilator? Now, I guess you could think of situations that go on for months and months, but taking something to court at the minimum is usually a few weeks, if not months. So AMD is one of the more difficult things to challenge. Now, one of the easier in terms of time, not in terms of expense and aggravation and everything else. You can imagine a will, the person's passed away, no more decisions to make in terms of healthcare, no more life and death decisions, sadly, too late for that. A will can be tied up in court for months or years because some potential heirs are challenging it. You can see how that could happen. Very aggravating, heartbreaking situations, but you could see how potentially there's time to do it. AMD, quite often, somebody's on a ventilator for 2 weeks and then either they recover or they pass away. It's going to be difficult to challenge AMD in that time frame, though legally possible.
Okay. Well, unfortunately, we're quickly running out of time, so I think we will have to kind of stop the questions right now. If anyone has any questions, they can always email us at info@seniorsactionquebec.ca. And, you know, Rick, if you're okay, if there's any follow-up questions, we can send them to you.
You're a community group that we're supporting. If you have questions, you can.
Perfect. Okay, great. So Ruth, do you want to wrap it up?
Well, Rick, once again, thank you very much. I thank everybody for sticking in there and learning as much as we can from these very important subjects. And I guess the message I would give to everybody, take the time and review all your paperwork and all your documents that you have. Bring them up to date and have somebody in your family that you trust and know, or a dear friend, know where everything is at. Rick, it's been tremendous. Thank you ever so much. And a little plug, March the 16th, we'll do our last of these series, and it's going to be on elder abuse and mediation. And one key topic is neglect, a form of abuse. We've all heard about physical, psychological, financial. So I encourage you all to register. It's already up on Seniors Action Quebec's website. It'll be March the 16th, and it'll be from 10 to noon, just like we have two lovely ladies, lawyer Ann Soden, who runs a free clinic for anybody of any income bracket, and Daphne Nemiash, who is a retired social worker and Canada's expert on identifying and knowing the signs of abuse. So once again, thank you all. Be safe out there. Enjoy the milder days, and we'll see you all soon.
And don't forget the evaluation, right?
The evaluation will be coming to everybody along with a copy of the recording or the presentation. And we ask you to please, please fill it out. Send it back, Katia and Whitney, because this helps us with our funders and governments, and shows the interest and how many people actually participated. Thank you, Rick.
Thank you, Ruth.
Thanks, Katia. Thanks, Whitney.
Thank you, Katia and Whitney. Have a great afternoon, Rick. Everyone.
Bye, everyone. Stay safe, stay warm.
Bye-bye.
Bye.